This week's assignments include completing a legal case brief. A case brief is a summary of a judicial opinion, and it includes information including the case name and citation, a summary of the key facts of the case, the issue that's presented by the case, the holding for what the court decided on that issue, as well as an analyzation of the reasoning of why the court decided to have the holding that the court did decide. For looking at this case, you are looking at it as part of the investigation into the Bradley Smart matter. As you remember from last week's material, Bradley Smart has come in with some sexual harassment issues by a supervisor at work. So this week, the case that you are going to be briefing is going to be relevant to that sexual harassment case. I want you to keep that in mind and keep the facts of his case in mind as you go through your legal brief, because this is the type of information that you would have when you were briefing a case for an attorney. And that attorney is going to look for the relevant information between the case at hand that he's writing for Bradley Smart and the case brief that you found and the facts of the case that you found, to see how we can compare and how that law can fit together. So the first thing that you're going to do with the case brief is you are going to look at the very top and get that name of the case and the citation. The citation is going to be a number here, and then it's going to have some letters here like U, S, and then it'll have another number there. And there will possibly be several different versions of this where it'll repeat over and over and over and over. These citations are going to tell you the number of the volume that it would be found if it was in print. This right here will tell you the book that it is in. And this is based on whether is it the Supreme Court, is it a state book here, is it a circuit court. So this will depend based on the jurisdiction of the court itself. Then this number right here will be the page number of that volume on which the court case started. And in lots of cases, I don't think in your Harris case, but you will also have a year here in addition to the court, depending on the whether it's the Supreme Court, you wouldn't need it, or some other top courts, but most courts you will include that here. But for this part, the key is including these citations with the number and the book and then the other number, and that's just so that you can identify that case, so that you can find it, so that your attorney will be able to look it up and that you can look it up. So after the name and citation, and by the way, the book gives us a guideline that this should be about 25 words maximum. So after the name and citation, then we're gonna have a summary of the facts. Again, we don't want to include too much here. We want to include the relevant facts. Think about which facts of this case, for example, are similar to the facts of the Bradley Smart case. And those are facts that you're probably going to want to include to see what similarities there are, as well as look for what's different, because you want to be able to have both the similarities and the differences. So we're looking for the key facts here, and not all of the facts. And this, the book again tells you should have about 125 words here. After you go into the summary of the facts, what comes next is the issue. The issue is the question that you're asking the court. In the Bradley Smart matter, for example, your issue is, was that conduct sexual harassment? And you're going to want to look under the law that they're looking at to see if that is sexual harassment. And that law, as you will see in the Harris case, is Title VII of the Civil Rights Act of 1964. So the issue is a question. It's not very long. The book is estimating at is 25 words. After the issue for a case brief, you're going to do the holding. The holding is the answer. How did the court answer your issue? Yes, was it discrimination? and why? Or no, it wasn't discrimination and why? So the holding is the answer to the question. This is what the case is saying, that yes, this is a violation of the law, or no, it is not. This is what they come up with, and again, this is about 25 words, and it usually will start with yes, and then a sentence, or no, and a sentence for what they decided. The last part of the case brief, which is the longest part, is your analyzation of the court and their reasoning. So this is where you're looking at their opinion and where they analyze these facts with the law. So the facts plus the law to come up with their holding. And then this is where they analyzed, and they said, based on these facts or based on these circumstances, they reasoned that the holding was yes or no. So for example, in the Bradley Smart, if they find that it was, sexual harassment, it might be because the totality of the circumstances, because it was his supervisor and it was making it very difficult for him to perform his job. So this is where you look at it. Or if they decide that maybe it wasn't enough to cause workplace discrimination, they found, a reasonable person would not have found that offensive. Or there was no psychological damage, so there was no harassment under Title VII. So this is the reasoning behind why they came up with the answer. Now I'm going to go through more in depth for those that want to stay on to talk about the actual case itself. And I'm going to be reading the case that you've been asked to brief and reading the different sections of that case, and then pulling out some of the things that I find important and asking you guys to do likewise. So at the very top, you'll notice the case name and the citation. That's the first part of the brief, the easy part. Get that written down. Next, we need to summarize these facts. The facts are the following. Teresa Harris worked as a manager at Forklift Systems Incorporated, an equipment rental company from April 1985 until October 1987. Charles Hardy was a forklift president. Throughout Harris's time at Forklift, Hardy often insulted her because of her gender and often made her the target of unwanted sexual innuendos. Hardy told Harris on several occasions in the presence of other employees, "You're a woman, what do you know? We need a man as the rental manager." At least once, he told her she was a dumbass woman, and again, in front of others, he suggested that the two of them go to the Holiday Inn to negotiate Harris's raise. Hardy occasionally asked Harris and other female employees to get coins from the front pocket of his pants, and he threw objects on the ground in front of Harris and other women and asked them to pick them up. He made sexual innuendos about Harris's and other women's clothing as well. In the mid-August 1987, Harris complained to Hardy about his conduct. Hardy said he was surprised that Harris was offended and said, "I'm only joking," and apologized. He also promised he would stop, and based on his assurance, Harris stayed on the job. But in early September, Hardy became anew. When Harris was arranging a deal with one of Forklift's customers, he asked her again in front of other employees, "What did you do? Promise the guy some sex on Saturday night?" On October 1st, Harris collected her paycheck and quit. So that is the facts that we have included right here. And I want you to think about what facts are important. If you were the judge, what facts would you be looking at? Some of the facts that I just pull out from reading that, how long she'd worked there, that he was her boss, that some of the comments were made in front of others, that she had asked him to stop. And then 2 weeks later, he started up again. So those are some of the relevant facts that I found. The next section for your case brief is the issue. And one of the easiest ways to look at the issue, and especially if this is a case that has been appealed, meaning that it has been already decided on by a lower court, but then appealed to a higher court, is to look at what those lower court opinions were. Because those are going to show you what is the issue that the lower court was deciding on. So let's read what the lower court's opinion is. It says, Harris then sued Forklift, claiming that Hardy's conduct had created an abusive work environment for her because of her gender. The United States District Court for the Middle District of Tennessee found that this was a close case, but held that Hardy's conduct did not create an abusive environment. The court found that some of Hardy's comments offended Harris and would offend a reasonable woman, but that they were not so severe as to be expected to seriously affect Harris's psychological well-being. A reasonable woman manager under like circumstances would have been offended by Hardy, but his conduct would not have given rise to the level of interfering with that person's work performance. The United States Court of Appeals for the Sixth Circuit affirmed in a brief unpublished decision. So, you can see the lower court. What was the lower court looking at? It mentioned there that they were looking at the level of abuse that would be required, to violate that Title VII of the Civil Rights Act by making a workplace, that was an abusive work environment. So the lower courts were saying that to have this abusive work environment, you had to have such severe conduct that it would affect an individual's psychological well-being. So they're looking for details that, yes, this conduct would affect her psychological well-being, this tangible, physical, mental behavior, rather than just looking at the overall circumstances of the work environment. So that's very important to keep in mind when we're looking at this issue. So the issue that it states here as part of your case brief says, we granted certiorari to resolve a conflict among the circuits on whether conduct to be actionable as abusive work environment harassment must seriously affect an employee's psychological well-being or lead the plaintiff to suffer injury. So right there, they've said what the issue is. They're looking at this Title VII of the Civil Rights Act and saying, do you have to have psychological harm or suffer injury to offend this Title VII of the Civil Rights Act and create this hostile work environment? And so think about that when you're writing your issue, that's what it's boiling down to. They're looking at what kind of behavior you have to have this hostile work environment. So the statute that they're interpreting is Title VII, again, of the Civil Rights Act of 1964, which states that it is an unlawful employment practice for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. So that is what they're looking at, this discrimination, the privileges of employment that are based on gender, especially here. But if there were, also race or religion or color or national origin, that would also come in under the same Title VII, for future court opinions. So for the issue, you looked at that, and now we're going to jump to what the holding was. So we're going to skip the reasoning for now and come back to that in a minute, and we're going to see what they said. The Supreme Court stated, we therefore believe the district court erred in relying on whether the conduct seriously affected plaintiff's psychological well-being or led her to suffer injury. Such an inquiry may needlessly focus on the fact finder's attention on concrete psychological harm, an element that Title VII does not require. So long as the work environment would reasonably be perceived and is perceived as hostile or abusive, there is no need for it also to be psychologically injurious. This is not, and by its nature cannot be, a mathematically precise test, but we can say that whether an environment is hostile or abusive can be determined only by looking at all the circumstances. We therefore reverse the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. So as you see right there, what did the court answer? Yes or no? Is that psychological harm required? No. They said, no, this is not required. You don't have to have this concrete evidence of psychological harm or this concrete evidence that you've suffered some injury. That you can still have, a hostile or abusive environment without having this psychological injury or other physical injuries showing. It says, this law, which we just read, that statute that was being interpreted, it did not say anything or require anything or elements of psychological harm. So their holding was that, no, you don't have to have this psychological harm. So find a way to word that. Again, just a sentence. And then the last part that we're going to jump to is why. Why did they find that holding? And this part can be the most complex, but it's also very important when you're applying the why to your own case. So we're going to look at the details of the Bradley Smart case. I want you to think of those in the back of your mind while you're looking at the reasoning to see, so would this fit with this Harris case, or would the Bradley Smart case not fit? And why? Why was it that they decided that it did violate the statute? So when we read the reasoning, I'm going to start right now. It says, when the workplace is permeated with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the condition of the victim's employment and create an abusive work environment, Title VII is violated. This standard takes a middle path between making actionable any conduct that is merely offensive and requiring the conduct to cause a tangible psychological injury. Mere utterance of an epithet which engenders offensive feelings in an employee does not sufficiently affect the conditions of employment to implicate Title VII. Conduct that is not severe or pervasive enough to create an objectively hostile or abusive work environment, an environment that a reasonable person would find hostile or abusive, is beyond Title VII's purview. Likewise, if the victim does not subjectively perceive the environment to be abusive, the conduct has not actually altered the conditions of the victim's employment, and there is no Title VII violation. But Title VII comes into play before the harassing conduct leads to a nervous breakdown. A discriminatory, abusive work environment, even one that does not seriously affect employees' psychological well-being, can and often will detract from employees' job performance, discourage employees from remaining on the job, or keep them from advancing in their careers. Moreover, even without regard to these tangible effects, the very fact that the discriminatory conduct was so severe or pervasive that it created a work environment abusive to employees because of their race, gender, religion, or national origin offends Title VII's broad rule of workplace equality. Okay, so think about what we just said there. Think about what was just said in their reasoning about why they found this situation to create that hostile and abusive work environment. They first of all talked about it being offensive to a reasonable person. That was part of their analysis, that they said, yes, this work environment would have been offensive to a reasonable person. If you have these really hurtful comments and discriminatory type behavior, and it would be offensive to a reasonable person, even if you haven't had this nervous breakdown, or even if you don't have this tangible physical harm, that still affects your job performance, your psychological well-being, and it might discourage you from being on the job. Here we have evidence that Teresa did quit her job at the end. That, the environment that was created was so hostile that it did lead her to leaving work. It did create harm. It did make her not want to go to work. So those are factors that came in, and that they also said it would have that same effect on a reasonable person. They also said, though, a little bit at the very end of that first paragraph, though, that if the victim does not subjectively perceive the environment to be abusive, then the conduct has not actually altered the condition of the employment. What that's saying is that if Teresa thought it was just a joke and she and her supervisor just joked around like that, and even though maybe another person would have found that offensive, if she didn't see that even as offensive and saw that as is just joking behavior, then that also would not rise to the level of, the hostile work environment under Title VII of the Civil Rights Act. So underline some of these words and look into some of these words that are used. You know, some of this permeating with discriminatory, intimidations, ridicules, and insults, sufficient or severe. You know, that's something that you will want to list in your reasoning. You know, that they're looking and saying that, you know, it still is affecting the job's performance. It still is affecting, you know, whether they stay or not, whether they like to go to work. It's affecting their raises because it's affecting their overall demeanor at work. So that is some of the reasoning to look at. If you have any questions about this case brief or are struggling at all, please do not hesitate to contact me. I hope this has helped. And as always, use complete sentences and spell check your work. Thank you and good luck.